Good afternoon and welcome to the Court of Appeals. We have one case for argument today. Your panel today is I'm Judge Stroud. To my right we have Judge Valerie Zachary. To my left, Judge Jeff Carpenter. And it looks like y'all are in place. Have you already arranged your rebuttal time? Okay, all right. And is it, okay, all right. He keeps up with it down there, just so I know what it is. Okay. All right, we're ready to proceed.
Good afternoon. May it please the court. I'm Michelle Ligori from Ellis & Winters for the appellant CarolinaLines. In March 2022, Superior Court Judge George Jones heard the Wardian faction's motion to disqualify Gary Shipman as counsel for GBR. Mr. Wardian and counsel were present. After Judge Jones determined that the motion to disqualify Mr. Shipman was unripe, former Superior Court Judge Bill Gore stood up and clarified that he was counsel for GBR. CarolinaLines then informed everyone present about the stipulation of dismissal that's the subject of this appeal. CarolinaLines announced that it was working with the Cantrell faction on a settlement that would permit a joint stipulation of dismissal without prejudice of its claims and GBR's counterclaims. Judge Jones asked everyone if there were any objections to CarolinaLines' request for an additional 24 hours to work on the dismissal. No one objected, and the court authorized the parties to enter a dismissal by 5 p.m. the next day. Judge Gore signed the dismissal, approving it on behalf of his client, GBR, not the Wardian faction or the Cantrell faction, but GBR.
So did Mr. Wardian object at all to Mr. Gore's statement that he was representing GBR?
No, he did not object. 2 years later, GBR asked a different Superior Court judge to strike the stipulation of dismissal. We're asking this court to reverse the order granting that motion because it can't be squared with the transcript of the March 2022 hearing before Judge Jones, and because the other facts in the law did not support setting the dismissal aside. I plan to start by addressing 3 key points about the facts in the law that show why the trial court erred in setting aside the stipulation of dismissal.
Before we get to that, I have a question about, I don't think there's any dispute, but that this is an interlocutory order.
Right.
Can you explain how this affects a substantial right?
Right, so under Rule 41 and the Supreme Court's decision in Brisson, when a party takes a dismissal without prejudice under Rule 41, they have a right to start the litigation anew. So it's a right to not to continue the current litigation, but to start anew in a new action. And that right will be lost if this appeal isn't heard now, because then we wouldn't be litigating in a new action, we'd be litigating in the action that's been dismissed.
That changes once a counterclaim's filed, right? You don't have the exclusive right to take a dismissal and dismiss the action. Once the counterclaim's filed, you have to have the consent.
You don't have a unilateral right to take a dismissal, but under Rule 41, you have a right to take a dismissal if all parties stipulate. And here all parties entered the stipulation of dismissal. And so under Rule 41, vacating that dismissal would take away the right we would have to start the action or to litigate in a new action.
It looked like when, in the brief, correct me if I'm wrong, please, but it looked like there was no case law on point.
Well, the Market America case is on point.
Is that in North Carolina?
Yes, so the Market America versus Lee case, it involved a notice of dismissal and held that an order vacating that dismissal affected a substantial right.
Mm-hmm. Go ahead.
In Market America, there's very little analysis on the Rule 41 substantial right. It basically just says there's a substantial right. That's the analysis.
It's correct. There's not a lot of analysis.
The analysis in Market America was whether or not the dismissal was taken in bad faith.
That's correct.
So is there any error in this order that can't be corrected on appeal from the final judgment?
Well, the order itself, the order deals with matters that don't relate to the merits of the claims. So the claims in this case are about whether there's a contractual right to sell property in Whiteville that CarolinaLines owns. The issues on appeal are about an internal control dispute that broke out within GBR a couple of years later after a mediation in this case. So continued proceedings in this case on the claims for breach of contract will not inform the court's analysis of the issues that are on appeal here.
Isn't there a lot of case law out there saying that avoidance of, of having to try a case is not a substantial right?
There is. And we're not trying to avoid trying the case here, but we have a right to litigate these claims in a new action.
You want to litigate it in federal court, not state court, right?
We filed in federal court. And this is like the right to arbitrate instead of to litigate. And this court has held that the right to arbitrate rather than litigate is a substantial.
Well, the right to arbitrate, though, isn't there a case law saying that basically that's almost a substantial right per se? Okay, and the situation that we're in here today is not. Am I correct?
There is no case that says it's a substantial right per se. The only case on point is Market America, which concludes that a substantial right is affected. As Judge Carpenter noted, there's not.
Doesn't Market America also say we assume without deciding the substantial right issue? Doesn't it also say that in the body of the case?
The Market America says it says we agree that there's that a substantial right is affected. It then proceeds to address a Rule 12 issue, and it grants a petition for certiorari on that issue. But on the issue of the vacator of the notice of dismissal, the court finds that the order affected a substantial right.
So it seems like it's more akin to a regular interlocutory order substantial right argument than to an arbitration type case.
I'm not sure I understand the court's question there.
Well, okay. What is your response to that, to that observation?
Well, I think this case is like any other case that involves an interlocutory appeal. We have to show that there's a substantial right affected by the order. The only case on point is the Market America case, which gives us a data point. In that case, the court concluded that an order vacating a notice of dismissal affected a substantial right. Here, the stipulation of dismissal gives us a right to litigate in a new action instead of in the current or in the dismissed action. And here, that's an important right to Carolinalines. We learned a lot about GBR, which relates to the issues on the contract claims, about GBR's ability to obtain financing during its internal control dispute. We want to conduct more discovery. We want to be able to have additional experts weigh in on the issues in the contract matter. And Carolinalines also has new counsel. It has different counsel now than it had in the original action.
How does that line up with you having a concurrent pending action in federal court? What are you going to do with the federal court action?
Right now, the federal court action is stayed pending.
Stayed waiting on us.
It is.
But it's still a concurrent trial court action. If this one goes back to the state trial court, now you've got two parallel, one in state court, one in federal court, on the same issue, same subject matter, same parties.
That's right. If this were to go back to state court, then the federal court would have to decide what to do with the case based on that.
Circling back to Market America for just a minute. Market America, it does say in the introductory language that the plaintiff asserts that it has a substantial right, and we agree. That's pretty much the analysis. But in Market America, it's a little bit factually different than this case in that Market America there was no counterclaim.
That's correct.
No need for consent there. So the plaintiff in that case had the exclusive right to continue or not continue the case. Does that make a difference?
It had a unilateral right to take a notice of dismissal. Here, the dismissal was not unilateral. It was a determination by both sides that a dismissal made sense on behalf of both sides. The effect of the dismissal is the same, though. It gives the party the right to litigate anew. And so I think that's the important thing for the substantial right analysis, because the order gives us a right to litigate in a new action, just like the dismissal gives us a right to litigate in a new action. The court's order upsets that, and that's the same thing that happened in Market America. The notice of dismissal would have given the plaintiff an opportunity to litigate in a new action. The order vacating that notice takes away that right, and the court found that that affected, well, the court found substantial right jurisdiction, and I think it's the same situation here that we had in Market America.
Market America is a little different in that the court had announced what it was going to do in regards to the Rule 12 issue in open court, right?
Meaning the trial court said it was going to deny the motion to dismiss, or excuse me, to grant the motion to
grant the
dismiss.
motion
Yes.
to dismiss. And then the plaintiff in Market America took a dismissal after the court
That's right.
announced, but before the order was entered.
Right.
Different than what we have here. This one hasn't gotten to that point yet. Does that make a difference in your analysis?
Here, meaning that here we don't, there was no determination from the court on the merits of the action?
Well, technically, there wasn't one that was reduced to writing and filed pursuant to Rule 58 in Market America either. But.
Well, there are a lot of differences between Market America and this case. So the ruling that Judge Jones announced in this case was on a motion to stay. It was not on a dispositive motion. And the Rule 41 cases really talk about dispositive motions. I think that analysis is more relevant on the bad faith issue than it is on the substantial right issue. I think the substantial right question focuses on the effect of the order and whether delaying appeal of that order would affect a substantial right of the appellant. I think what happens at the hearing and what the court said and when the dismissal is taken, I think affects the merits of the order vacating the dismissal. And I think the Market America case shows that, because the court in Market America found ultimately that the dismissal was taken in bad faith. That didn't mean there wasn't a substantial right affected by the order.
That takes me back to my question before. The court also said in Market America, Judge Davis drafted that opinion, that when they were dealing with basically the summation of the bad faith, they were assuming without deciding. The truth is they didn't have to get to the substantial right issue because they granted the certiorari as to the bad faith.
As I read the Market America case, the court didn't grant a petition for certiorari regarding the order vacating the notice of dismissal. It granted the petition for certiorari on the Rule 12 issue. If the court could have granted a petition for certiorari on both issues, though. But as I read Market America, I think they say we agree there's jurisdiction.
I guess what I'm getting at here is if the determination was there's a substantial right as to the right to take a dismissal, but the court didn't need to decide the issue to get to the issue that was dispositive of the case. Is it dicta or is it a holding?
Well, the merits of in Market America, they reverse on the Rule 12 issue. If the court hadn't ruled on the notice of dismissal question, then the case would have been I don't think that the ruling on the substantial right issue is dicta, because the court decides that the order affected a substantial right. I think the court then proceeded to address another issue. I don't read the case for the ruling on the substantial right to be dicta. Regarding the 3 points that show why, the 3 points about the facts in the law that show why the trial court erred in setting aside the stipulation.
Let me ask you something on that. So it was a little bit complicated for me to figure out like what the order is, because we have an order that's appealed, and it adopts and incorporates findings of fact from a previous order. So we have those findings. And then that order adopts and incorporates some findings from Judge Sasser's previous order, which also talks about the Kentucky Court of Appeals opinion of the law of the case. So I'm like, so I have this whole stack of things that's actually the find, or not all of it, but as far as the findings. So I was trying to figure out which findings of fact you're actually challenging as unsupported, one. because then we have our facts.
Mhm.
And then exactly which conclusions of law, because they're a little mixed together in the order. Like some of the things that are under conclusions of law are really findings. So which facts specifically are you claiming are not supported?
Mhm. One of the facts we challenge is the court's finding that the Wyoming stipulated motion to dismiss and the order granting that motion resolved who was in control of GBR in March
But I
of
mean,
2022.
which finding, what number, or is it? Because I mean, I normally look, maybe I'm just simple this way, but I normally look for like, oh, finding of fact number 5 is challenged, and that, you know, so I see your argument regarding, but I'm trying to figure out exactly where it is.
So finding of fact 33 addresses the Wyoming order, and that we're challenging that as unsupported.
Okay.
We've also,
And so I'm assuming that the findings that are incorporated, you're not really specifically talking about any of those.
no, we didn't challenge the incorporated findings.
All right, so we're just in here, that's good.
We've also challenged finding of fact 27 regarding which finds that addresses consideration.
Okay.
And then we challenged, relatedly, conclusion of law 11, which is kind of related to that finding of fact.
Okay.
And then we've challenged the court's discussion of Mr. Gore, where the court says that the court says he's not authorized to enter the stipulation of dismissal, and that I believe that's sort of discussed in various places in the order, not necessarily in one particular paragraph of the order. So I can't point the court at this time to that, though we do specifically address in our brief the findings of fact, and we do discuss the finding that Mr. Gore is unauthorized, and we do cite to the order in there, so I apologize, Your Honor, I don't have that off the top of my head.
All right. Okay. All right. Thanks.
So the first key point is that the settlement agreement that Carolinalines entered with the Cantrell faction in March 2022 was conditional on the outcome of the Wyoming litigation. The entire settlement agreement is in the sealed record supplement. The plain language of the agreement shows that it was conditional on the outcome of GBR's internal control dispute. One of the conditions of GBR's obligations under the agreement is, quote, GBR shall have received confirmation from a court of competent jurisdiction in Wyoming of its authority to enter into this agreement. That's on page 298 of the sealed record supplement. Carolinalines' obligations under the settlement agreement were also conditioned on receiving, quote, a final non-appealable order from a court of competent jurisdiction in Wyoming resolving the GBR shareholder dispute and approving the settlement agreement. That's on pages 298 to 99 of the sealed record supplement. And the conditional nature of the settlement agreement is consistent with Carolinalines' motion in January of 2022 to stay the litigation. That motion recognized that Carolinalines could not enter a binding settlement with either of the two competing factions within GBR. Carolinalines did not attempt to enter a binding settlement with either of the two competing factions. Instead, it memorialized an agreement that one of those factions agreed with, so that if that faction did prevail in the internal control dispute, that settlement could go forward and the litigation would be resolved. If that faction didn't prevail, then the case would start anew. Each side would be able to litigate anew. The second key point is that there's a presumption under North Carolina law that an attorney who professes to represent a client can act on behalf of that client. GBR acknowledges this in its brief, citing the Harris versus Ray Johnson construction case. This presumption means that Judge Gore, as GBR's counsel, presumptively had authority to act for GBR. And under Harris and cases applying it, there's a high standard for setting aside the act of an attorney. the client must prove, quote, to the satisfaction of the court that the attorney was unauthorized to act. The trial court's findings here show that GBR did not prove to the satisfaction of the court that Judge Gore was unauthorized to act for GBR. In finding of fact 24, the court says, quote, it is unclear to the court if the Wardian GBR board had authorized continued settlement negotiations with RJC pending the resolution of the Wyoming action and disqualification motion. In conclusion of Law 10, the court refers to, quote, potential conflict of interest of Mr. Gore. This and the record did not meet the high standard for setting aside the act of an attorney, and it shows that the trial court applied the wrong standard when it set aside the stipulation of dismissal. Under this court's decision in Purcell, the act of an attorney will be upheld if a third party reasonably could have believed that the attorney was authorized to act. Here, Carolinalines said at the March 2022 hearing that it was working on a stipulation of dismissal with Mr. Gore and Mr. Shipman, and no one objected. The trial court then authorized the parties to enter a stipulation of dismissal. It gave them 24 hours to do so. And based on that, Carolinalines reasonably believed that Mr. Gore had authority to sign the stipulation of dismissal for GBR. The third key point is that the stipulation of dismissal did not prevent GBR from having its claims heard on the merits. The dismissal expressly incorporated a tolling agreement. And North Carolina law recognizes the enforceability of tolling agreements, where parties can waive their right to bring a statute of limitations defense. Here, Carolinalines waived any statute of limitations defense it had against GBR, at least until December of 2024. GBR's arguments on appeal focus on who signed the tolling agreement for GBR, but there's no suggestion that Carolinalines' waiver of the statute of limitations defense would not be enforceable. So here, after GBR's control dispute was resolved in the summer of 2023, GBR could have refiled its claims in state court. We've since filed the claims in federal court. Now GBR can file its claims as counterclaims in federal court. And so there's nothing preventing, the stipulation of dismissal did not prevent GBR from having its claims heard on the merits. And this matters because the trial court's order is premised on the stipulation of dismissal, preventing GBR from having its claims heard on the merits. Conclusions of Law 5, 6, and 7 all show this. Paragraph 5 says the court finds that the dismissal became a final adjudication for purposes of a Rule 60 motion once a year had elapsed since its filing. The court in paragraph 6 again references a final adjudication, saying a motion for relief from a final adjudication under Rule 60 is addressed to the sound discretion of this court. In paragraph 7, the court says procedural actions that prevent litigants from having the opportunity to dispose of their case on the merits are not favored. So these paragraphs show that the court was operating under the presumption or under the understanding that GBR's claims were final, that it couldn't have its claims heard on the merits because of the stipulation of dismissal. And that's not true, because GBR could have filed those claims after its control dispute was resolved, because the tolling agreement had waived any statute of limitations defense. I'd like to turn to the court's ruling under Rule 41. So the trial court vacated the dismissal under Rule 41 based on a finding that Carolinalines took the dismissal in bad faith. The trial court didn't cite any law for finding bad faith on the facts here. In our brief, we cite the Supreme Court's decision in Bundy versus Commercial Credit, which defines bad faith as having, quote, a false motive or purpose. Under this court's decision in Calc-Braithwaite, the court reviews de novo whether there's a basis for finding a bad faith exception to a Rule 41 dismissal. The trial court erred here by applying the bad faith exception because the transcript of the March 2022 hearing shows that Carolinalines was open about its motive and purpose. Carolinalines announced that it was working on a settlement with the Cantrell faction that would permit a joint stipulation of dismissal of the case. The settlement was conditional and would not bind the Wardian faction if the Wardian faction prevailed in the internal control dispute. The purpose was to preserve the settlement that Carolina Lines had reached with one faction of GBR. Brisson recognizes that a party has a right to take a dismissal, quote, for whatever reason. There is no authority for applying the bad faith exception here. This court's recognized only two forms of bad faith. The first is where a party files a sham complaint, so filing right before the statute of limitations expires for the sole purpose of extending the statute of limitations. That's not applicable here. The other situation, as Your Honor mentioned earlier, is where the court announces a dispositive ruling and the party races to the courthouse to get a dismissal entered before the court has a chance to enter that dispositive order. None of the things that Judge Locklear pointed to here support her finding of bad faith. And we've addressed a few of them already, just to address the ones that we haven't touched on yet. The court notes that Carolina Lines had knowledge that Judge Jones was going to stay the action. That's true as a matter of fact, but doesn't support a bad faith finding because Judge Jones expressly gave the parties authority to enter a dismissal until 5 p.m. the day after the hearing. The court also says that Carolina Lines seeks to avoid the trial court's rulings on the summary judgment motions, and this is inconsistent with the timing of when things happened. Summary judgment occurred a year earlier, and there's nothing to support a conclusion that Carolina Lines took the dismissal because it wanted to have another chance at summary judgment. In any event, under Rule 41, a party can take a stipulation of dismissal at any time before final judgment. It's different than a notice of dismissal, which a party has to take before it rests its case. A stipulation of dismissal can be taken anytime.
So you're into your rebuttal time.
Okay, thank you, Your Honor. I'll save the remainder of my time.
Okay.
Good afternoon. May it please the court, my name is Aaron Lay with the law firm of Hamilton, Stevens, Still, and Martin. I have with me today my colleagues Sarah Cheeley and Graham Morgan, as well as client representatives. I represent GlobalBioRin Incorporated, the appellee in this case. At the onset, because Your Honors raised the question, I think we need to address Market America more thoroughly. There is not a substantial right effect here. They cite to Market America as being on point, but it is not. What Market America, the order in this, did several things. The order granted by Judge Hynett said it granted defendant's motion to vacate the voluntary dismissal. That was the first action on the order. That's what it took in order to reopen that particular case. But the more important third holding was it also, in that same order, dismissed the claims against Lee with prejudice to the extent that those claims were based upon a breach of paragraphs 18B and 18C. So what the court then says, when they point to this, what I think, Judge Carpenter, is dicta, says here Lee concedes and we agree the substantial right is effective with respect to the trial court's order vacating Market America's voluntary dismissal. But if you read Lee's brief, what he actually only concedes was that there was a substantial right affected in regard to that order to the extent it dismissed those claims of Lee with prejudice. And so I do agree, I think that's dicta. It's not necessarily on point. Having said that, Your Honors, this case provides the court with the opportunity to protect the equitable powers of the trial court to set aside a voluntary dismissal that's been wrongfully procured. If the court adopts the interpretation of the rules advanced by Carolina Lines, it will undoubtedly create a procedural no man's land for relief from voluntary dismissals without prejudice. Here, the trial court appropriately granted the necessary relief under 3 separate rules of civil procedure: Rule 41, 60B, and 12F. And this court would have to find that none of those grounds and rules were appropriate in order to rule in favor of Carolina Lines. First, Rule 41 empowers the trial court to set aside a dismissal that is either void or the product of bad faith. Rule 60B provides a broad reservoir of equitable power, allowing the trial court to look back to the final act that closed the case, reopen that case. And that final act can include notices of voluntary dismissal with or without prejudice. It does not matter because that's a proceeding that closed that case, and provide relief from that act, thereby reopening that case, undoing the wrong, and returning it to the same procedural posture it was before that final act occurred, thus unwinding any inequity that occurred. Finally, Rule 12F provides the trial court with further equitable power to strike a stipulation of dismissal wrongfully filed by parties on prior counsel. Unless the court requests otherwise, I plan to proceed in the following order, but I'm prepared to answer any questions. I will briefly address some of the salient background, discuss the singular finding of fact and singular conclusion of law disputed by Carolinalines in their brief, those that they did not dispute, they have waived any dispute to, and then address, in this order, Rule 41, then Rule 60B, and finally, if time allows, Rule 12F. Now, many facts have been misconstrued in Carolina's briefs and argument, which the record and transcript should provide clarity on. I would say that the contention that we never objected to Mr. Gore's authority belies the fact that we spent an hour and a half saying that the Wardian faction had no authority to direct Mr. Shipman or Mr. Gore or settle the matter or do anything on behalf of GBR. And that goes back to the principle. If the principal is not granting the authority and it's been made clear, and we contend that we were the principal the whole time, then there can be no authority given, and that was quite apparent that day. But this underlying litigation, this matter, relates back to a 2018 contract and a breach, we allege the breach of that contract by Carolinalines, which has started off a saga of litigation that we're now in our 7th year of. And after years of litigating Columbus County and Kentucky, and on the precipice of trial, we did have an intercorporate dispute that broke out over GBR's constituency. That was fanned in large part by Carolinalines' offer of settlement, and the Wardian, Mr. Wardian and his group that was in control at the time, the officers and directors, had rejected that settlement. That did not set well with certain people that were involved in GBR, and so they launched this effort to issue new shares, do a consent action, and remove Mr. Wardian. That action did not work. Those shares were not credible shares, and that's covered in the Wyoming stipulation that we'll get to. So at that point, there was questions of who had authority to even direct the litigation, direct the attorneys, make any decisions on behalf of GBR. And to clear that up, the Wardian faction goes to the Wyoming court, files an action for declaratory judgment action, doing one of two things. One, say that these guys, the Cantrell faction, are not shareholders, and two, that the shareholder action was not effective, past tense. And they brought that. And along with that, we moved to stay at the trial court in order to prevent this whole situation from happening, in order to prevent someone acting without authority, so that the court in Wyoming could determine, ultimately, who the constituency of GBR was. They knew this, Carolinalines did, and they proceeded forward. Judge Jones knew this. He explained that he can't even determine who GBR is at this point because he doesn't know the constituency, doesn't know the shareholders. He can't tell who the client even is in his consideration of our arguments on the rules of professional conduct as to who Mr. Shipman answered to at this point, who Mr. Gore would have answered to at that point. And so, rather than rely on the stay, they proceed ahead. They chose a faction. They chose a side, the one that ultimately was not in control and never was in control. And therein lies the bad faith itself. The disputed finding of fact number 13 that was brought up is the Wyoming stipulation and order affirms the Wardian faction was in control of GBR at all pertinent times. That includes the times of the settlement and the filing of this dismissal. And so they had not granted authority. And the standard of review here is this court is to uphold it if there's any competent evidence in the record that supports that finding.
I have a quick question.
Yes, ma'am.
Okay, in finding of fact number 19 in the order, it looks like Carolinalines should not be allowed to use bad faith procurement of the dismissal in order to avoid the adverse effects of prior decisions of this court. Can you explain to me what Judge Locklear was talking about?
Yes, Your Honor. So if we look at the tolling agreement, there is two poison pills in that particular stipulation and tolling agreement. And it's the agreement, and it's in the record, page 198, that they say shows they acted in good faith in order to toll everything so that we could figure out control in Wyoming. But if we look at paragraph 3, and it's the statement on the intention and promises of the parties, here's what they negotiated. A, all prior rulings in the covered action, being the Columbus County action, will be given the same effect as if the rulings had been entered in the future action. So we start back where we were. No additional discovery would be needed. The parties will file any renewed action in the Superior Court of Columbus County. So we start back, and that way, and then they even said that all the prior holdings would be given the same effect. But here's the poison pill that they put into it. The parties agree that in the event that GBR is not represented by Shipman and Wright, LLP, the very firm we moved to disqualify and accuse of unethical behavior, in any future litigation filed by any party, neither party would be bound by sections 3A through 3C above. They guaranteed one of two things would happen, that GBR would either have to affirm this or it would go to federal court where they get a new shot at all dispositive motions because the state's prior holdings would not bind the federal court. Or we had to hire Shipman and Wright, and they knew at that point, after we argued for an hour and a half, what Shipman and Wright had done wrong, that there is no way that the Wardian faction, after retaining control and that being upheld in the Wyoming court, would hire Shipman and Wright. So that's where a lot of bad faith lies. Is they made sure that the Wardian faction wouldn't have any say at that point.
What are the orders they're trying to, the decisions on orders that they're trying to avoid?
I'm sorry, Your Honor, I didn't.
What are the decisions on orders that they're trying to avoid?
The decisions were, well, it was denied, summary judgment was denied as to both, so it gets to proceed. And particularly here, because it's a contract action, there were questions involving the proof of funds. And that's a very important question in this case. And so it was decided that there was enough evidence there to move forward to the jury. They also dismissed, I understand, several of the affirmative defenses that were asserted by CarolinaLines. And so those prior holdings and findings of fact and conclusions of law would assist us going forward. And that's why we're here. If none of that mattered and we wanted to restart, we could go to federal court. But that's not what we want to do. And that's the purposes of the rules is to allow the trial court to undo a wrong that they have found inequitable and reopen the case so that we could start exactly back where we were. So if we look at stipulation of dismissal in Wyoming, it actually gives us everything we need. Because, one, it starts out by saying the parties have resolved all claims. The only claims between them were on the deck action, whether or not the Cantrell faction were shareholders, and if they were, and that was answered no, they were never shareholders. And then the second one was whether the Cantrell faction, the consent action they attempted to remove Wardian faction as board and officers, whether it was effective. And what the stipulation said was no, it is and was not effective. Now they keep saying that it was only forward-looking, but the language is right there in the stipulation itself. Was not effective. So if the consent action was not effective to remove the Wardian board and officers stayed in place the entire time. Now, you don't even have to take my word for it necessarily. Look at their own federal declaratory action that they filed. Within that action, they admit in paragraph 27 of it, the joint motion stipulation resolved all claims in the GBR shareholder dispute. The Cantrell GBR waived all claims being shareholders and actions is or was effective. 48, Wardian GBR was the prevailing side in the shareholder dispute. 36, the joint stipulated motion provided Wardian, not Cantrell, was director and CEO president when the settlement agreement was executed. This is their own admissions, their interpretation of the stipulation in order, the same interpretation that Judge Locklear reached until it was no longer convenient for CarolinaLines to have that interpretation. Paragraph 37, GBR was not under the full direction and control of Cantrell, and Cantrell was not the CEO president during negotiations and execution. And more importantly, the person that signed these documents, including the settlement agreement and the tolling agreement on behalf of GBR, what Carolina Lines alleged in their federal complaint was Morgan, Ken Morgan, was not at the time of the settlement agreement a shareholder, director, or officer of GBR. 49 of their complaint. Morgan did not have a proper authority pursuant to applicable corporate law for the properly constituted shareholders or board of directors. And finally, 51, Morgan lacked the authority to negotiate or execute settlement agreement null and void. Moreover, they talked about how their settlement agreement was conditional. That in and of itself tells me that they knew that there was a question of authority by the attorneys and the people proposing to act on GBR. Otherwise, it would not have had to be conditional. So they were on full notice. The conclusion of law that was disputed. Now, this is, and that's, I believe, number 12, although they say they point to several others, but only in brief it appears that they're pointing to conclusion of law number 12. And that the court also finds that GBR, as it is currently constituted and has been constituted all relevant times, did not authorize the filing of a dismissal. Well, based on the prior finding of fact, for the reasons I explained, if the Wardian faction had control at all time, including through the dismissal, Carolina Lines knew that they would have to authorize Mr. Gore. If you look at the transcript, they say that they are negotiating the stipulated dismissal and settlement agreement with Cantrell faction, Shipman, and Gore. No discussion with Mr. Wardian and his faction on these matters when we were there in court. And the transcript shows that we did not approve it. The only thing that happened is after Judge Jones had said, I can't make a decision because I don't even know who can speak on behalf of GBR or who has authority to authorize these attorneys to do anything or who these attorneys' clients are. We took no position on the matter of the settlement agreement because we were not aware of the terms being proposed or anything else. That was the only position taken.
How do you respond to your colleague's argument that Wardian was present when Gore said he had authority to act and didn't say anything?
No one said Gore had authority to act. Mr. Gore got up to defend himself because there had been a lot of talk from Mr. Shipman. If you look at the read through the transcript, Mr. Shipman says, I hired Gore. We're working on this. They told us, GBR said, go settle it. Me and Gore did. And he said, are you accusing Gore of wrongdoing? And went through a tirade. And what we said is, we're not accusing Mr. Gore of anything. What you'll see in the transcript is, we've had no communications with Mr. Gore. We don't know what his role is at this point. So that was only in relation to the disqualification of Mr. Gore, because we didn't have the information that Mr. Gore had engaged in any wrongdoing. Because what Mr. Shipman said there, and what's confirmed by Mr. Wardian, is Mr. Shipman engaged Mr. Gore as his local counsel to advise on local matters. This goes beyond that, and that's a limitation on the authority as well. Local counsel generally are not empowered to make decisions on behalf of the client when it comes to settlement and those things. And that was clear that day. If it wasn't clear, they had the opportunity to ask myself or Mr. Wardian. They cherry-picked that transcript to pick one thing out to say, well, that was the authority. No one, no good lawyer would advance on that authority by just saying we don't object to him stating he's still the counsel of record, because we had just been told by Judge Jones that we didn't even have standing to challenge that at that point. So if nobody can challenge, because that was Judge Jones' whole point, nobody can challenge which lawyer should be disqualified or terminated at this point. And so Mr. Wardian didn't understand that he was asking if there was an objection to filing stipulation of dismissal or settlement agreement. Quite the opposite. We understood that to be known because the whole fight was over Mr. Wardian refusing to sign a settlement agreement and enter the dismissal. And that's well covered in the motion to disqualify Mr. Shipman. That's how this whole fight arose. So the fact that they would believe suddenly that Mr. Wardian had to change of heart and decided, yes, please sign this stipulation for me. That is, anyway, I'll move on. So they cited Purcell, but Purcell is, what it says is there still has to be three conditions exist there. The agent acts within the scope of his apparent authority, and the third party has no notice of limitation on such authority. For the reasons I've just given you, there was clearly notice on limitations. Because if you go back, and finally Purcell, before I address that point I was going to make, the third person in the exercise of reasonable care was justified in believing that the principal had, under other circumstances, conferred upon his agent. And that language is important. They needed to understand that the principal had conferred the authority, and they could justifiably rely on that. If the judge has just said, we don't know who the principal is and who controls the principal, and we have just said that we are the principal and we're not given the authority, then they cannot be justified in relying on that. There's no reasonable reliance there. And if Mr. Gore was acting on behalf of Mr. Wardian and GBR at that time, I would not have been needed to intervene and been hired by Mr. Wardian in order to move to stay the trial. So it was clear that we were not giving any authority for anyone to continue acting on behalf of GBR, hence why we asked for the stay. And I would note, remember, they filed their own motion to stay after the Wyoming action was filed. And what they said, and that's quoted in the orders, is we don't know who has the authority. They admitted on the record in their own motion that they could not know who has the authority to act on behalf of GBR, and that they cannot move forward with settlement negotiations. It had already been admitted of them. Nothing during that hearing would have changed that. And because of the settlement agreement is void, and the admissions that they have in their own declaratory action, that Mr. Morgan did not have the authorization to sign both the settlement agreement and the tolling agreement would automatically make it void if there's no authorization to sign there. Rule 41, and we went on 41 just on the requirement that it be signed by all parties. Now, the judge has already found that Mr. Gore did not have the authority. The Cantrell faction, who directed the signature on the tolling agreement and the stipulation, did not have the authority. So not all parties had signed this dismissal. And bad faith is not limited to two circumstances. In fact, what Market America says is the dismissal must be taken in good faith. And they are unable to agree to the limited specific types of bad faith set forth in Estrada and Hawkins. Because bad faith, and this is a quote from it, bad faith can exist in a variety of forms. So Rule 41 doesn't limit it to two forms of bad faith. Those cases just gave the examples that were before them, and it's based on the circumstances that were before them. But it's quite clear that it's meant to go beyond that. Eubank versus Real says, to the extent to which voluntary dismissals taken under a different set of circumstances should or should not have been deemed to have been taken in bad faith must be determined on an individualized basis. Because the trial court has to have this broad discretion to determine what is bad faith, because the circumstances and facts before them will differ each time. And so they need that reservoir of power in order to set aside a dismissal that wasn't filed in good faith. And I don't think anybody can argue that this one was filed in good faith. In fact, for the reasons I explained in the stipulation and the tolling agreement, they rely on that to say, well, they acted in good faith. Well, what they did is they locked out the Wardian GBR on any discussion on the settlement and tolling agreement. One of the reasons you see that Judge Jones entered an order after the dismissal was we didn't even know the dismissal had been filed. It wasn't clear at that point. So we were locked out of all that. And then they included those poison pills in the stipulation. And one of the other poison pill was they only extended the statute of limitations to December 31st, 2024. At that point, we did not know whether or not the Wyoming litigation would have even been resolved, forcing them to either affirm or go back into federal court. So you see, Carolina wins. They set it up to where they win either way. Either the settlement agreement that we believe was preferential to Carolina Lines and one that the Wardian faction, who was in control of GBR, would not have agreed to it, or we get a whole new clean slate in federal court and have to move forward. Rule 60B, there's no abuse of discretion here. The purpose here is it provides an avenue to provide relief to reopen closed cases, closed by either a proceeding, order, or a judgment. They're trying to read this Rule 60B very narrowly. I don't believe there's conflicting cases here, and here's why. Because each one of those, proceeding, order, or judgment, should be read more broadly. Judgment being the most narrow, then order, and then proceeding. And we provided a case to the court on the federal interpretation of Rule 60B. In that case, the federal Rule 60B, North Carolina's rule is based on that case. So it's very instructive. And that's why the first case in North Carolina Court of Appeals that even addressed notices of dismissal in relation to 60B was Carter v. Clowers. And they cited to the federal approach that notices of dismissal, and they just left it, notices of dismissal is a proceeding to which 60B applies. They didn't say whether it's with or without prejudice, and there's a reason for that. If we look at the case that was provided, it's Whitesig versus Halliburton Energy Services Incorporated, 604 U.S. 305, and it's a U.S. Supreme Court case, a unanimous case of the U.S. Supreme Court, and we know that doesn't often happen. And they say things a lot more eloquently than what I'm able to do today for you all, so I will read some of their statements. And what they say is a case is voluntarily dismissed without prejudice under 41A counts as a final proceeding under Rule 60B. Final because it terminates the case, even if a new action can be filed, because that particular case is then closed. And the trial court needs a mechanism to reopen that case without filing of a new one. And after a case is finally terminated, a court no longer presides, and a party can no longer seek a rehearing on an interlocutory judgment. So it is at that point that a court's power under Rule 60B kicks in, permitting the court to look back at that final act in a case and provide relief from that act when appropriate. A voluntary dismissal without prejudice is one such final act. It terminates the case and strips a court of its equitable power to revise its earlier rulings. A contrary interpretation would place voluntary dismissals without prejudice into a procedural no man's land, exactly what Carolina Lines argues this court should do. Such dismissals would not be interlocutory. And then they looked at the text, context, and history that supports this conclusion. Legal dictionaries from 1938 to present have suggested the term proceeding encompasses all steps in an action, including notices of dismissal with or without prejudice. When we look at Rule 60B, it authorizes relief from a judgment, order, or proceeding. It does not limit itself. The rule speaks in an ascending order of generality. The structure of the rule suggests that each term should be read as broader than what came before. Any judgment will generally involve an order, but not all orders are judgments. That suggests that each term should be read as broader than what came before. Just as order encompasses and exceeds judgment, proceeding should encompass and exceed order. It would be odd, therefore, to read proceeding as covering only those acts that are already covered by the term order. And what this court did in Carter v. Clowers is they adopted that federal approach. They cited Nolan versus Floor Fabricators, and they said that a notice of dismissal was a proceeding for purposes of Rule 60B. Notably, Nolan v. Floor Fabricators was considering a notice of dismissal without prejudice, the very case that Carter v. Clowers relied upon. Now, they point out Troy, which is a case decided a couple years later, but the prior precedent rule applies here. Troy didn't even mention Carter v. Clowers. And there's not an analysis of that. It's just one sentence, essentially, saying, well, it wouldn't apply to 60B. But they totally ignored the holding in Carter. Then Robinson v. General Mills, again, they discuss the notice of dismissal without prejudice to be a final judgment. But that fits with what the Supreme Court said. A notice of dismissal is a proceeding. If a notice of dismissal is with prejudice, it can also be a judgment. They fit in together. And if a notice of dismissal without prejudice goes past, and it's not refiled within the saving provision of 1 year or the statute of limitations, it too becomes a final adjudication. So all that those cases are saying is you can have a proceeding that's not a judgment, but once that proceeding becomes final, as in a final adjudication, it is then considered a judgment as well. So 60B would apply to both. Even if you took the alternative approach to saying, okay, well, a notice of dismissal without prejudice is a proceeding, and so only subsections 1 to 3 of 60B would apply versus a final judgment, 4 to 6 would apply. For the same reasons that we've discussed, we went under either scenario, Your Honors. Whether you treat it as a proceeding that only 1 to 3 would apply, because the facts were found in the order that support 1 through 3 as well. And then 4, 5, and 6, which specifically refer to judgments. For the reasons we've set forth, that notice of dismissal, stipulation of dismissal without prejudice became a final adjudication because the 1 year had passed, the statute of limitations had told. Now on that matter, they want to argue, the two cases they cite to are dealing with tolling of statute of limitations for service purposes. So the statute of limitations doesn't expire between the time you file an action and the time you actually serve as defendants. It's to protect you during that period. It doesn't then take any of that time and tack it back on to the end of the statutory limitations. That is improper reading in those cases. And the tolling agreement, for the reasons I've set forth, does not revive because it was void. By their own admission, it was void because Ken Morgan couldn't sign it. And it was not authorized to be entered into by GBR. And we've gone through, everything I've said today is an extraordinary circumstance that falls under 60B6. Even if you look at the subsection 1, 2, 3, there's a 1 year limitation on that. But one of the extraordinary circumstances here was Mr. Wardian's faction, who controlled GBR, was not authorized to act in this trial court until the Wyoming litigation was determined and control was determined. So that is one of the extraordinary circumstances. We could not even act with that within that 1 year. It was not decided until July 2023 who was the constituency of GBR by the Wyoming court, and then we moved soon thereafter. Now, Rule 12F.
If we go with you, what do you want us to do?
Send it back to Columbus County and let us start and finish this case out. Thank you, Your Honor.
Thank you, Your Honors. I'd like to start by discussing the argument that Judge Jones and everyone at the March 2022 hearing acknowledged that there was questions about who the client was within GBR, and so it was clear that a binding settlement couldn't be reached until GBR's internal dispute was resolved. Judge Jones acknowledged that. Carolinalines knew that. That was clear to everyone at the March 2022 hearing. But Judge Jones authorized the parties to enter a joint stipulation of dismissal without prejudice, and that's different than a settlement. And it's helpful to look at the rules of professional conduct, specifically Rule 1.2a, and subsections 1 and 3 distinguish between what an attorney can do, or the roles of the attorney and the client with regard to a settlement, and the roles of the attorney and the client with regard to determining whether to assert or to waive certain rights or positions of the client. So it's the client's determination whether to enter into a settlement, but an attorney can exercise their professional judgment in determining whether to waive or to not assert a right of the client. And the stipulation of dismissal and the tolling agreement here fall under under Rule 1.2a3. That's something where Judge Gore made a determination that the stipulation of dismissal without prejudice was in GBR's interests. And he, as an attorney, could make that determination because it relates to whether to assert or to waive certain rights or positions of the client. It is not entering into a settlement. And everyone knew that we needed a determination of who's in control of GBR to decide whether the claims can be settled. But the attorneys have the ability to make certain determinations about how strategic determinations, including...
Mr. Shipman hired Mr. Gore, not GBR.
That was not discussed in March 2022. So that is in Mr. Wardian's later affidavit about the specifics of how Gore was hired. We don't have any information other than what Mr. Wardian says about that. But that, number one, that was not discussed at the March 2022 hearing. And regardless of who hired Mr. Gore, he's counsel for GBR. He has duties to GBR.
Can he just show up and say, hey, I don't know these folks, never met them before, but I'm counsel for them and I'd like to dismiss their case? Can he do that?
I don't think he could do that. He says, I'm counsel for GBR. I've worked with Wardian. So the transcript shows he says, I participated in the mediation. Mr. Wardian gave me permission to do so. He talks about discussions he's had with Wardian. Counsel mentions that the people within GBR have talked with Mr. Gore. No one had anything bad to say about him. So it's not true that Mr. Gore had never had any interactions with Mr. Wardian. But Mr. Gore affirms on the record he's counsel for GBR. And he's the one who signs the stipulation of dismissal. This court has recognized an attorney can sign a stipulation of dismissal. It need not be signed by the client. So that explains why Judge Jones was comfortable with the parties moving forward with a stipulation of dismissal. I'd just like to say very quickly, this court's decision in Robinson addresses whether Rule 60B relief applies here, and it shows that it does not. If the court has no further questions.
If we go with you, what do you want us to do with the case?
We want you to reverse the court's order vacating the stipulation of dismissal.
And do what?
That would end the case, and then we would proceed in federal court.
Thank you.
Thank you.
Thank you. Thank you all for your arguments. And we will adjourn, and we're going to come back for a swearing in.
Been waiting for this moment.